Well, I'm so glad that you're here. So the agenda is pretty simple today. What we're going to do is first of all, we're going to hear from Colin Marazzi from ACLU, Ohio. He's going to talk about Senate Bill 293 and the litigation surrounding it. Many of you will remember that this is the bill that actually eliminated the grace day period, but also created a bunch of different administrative challenges for citizenship verification. So that's that legislation. Then we're going to talk about the redistricting wars, the fallout from the Callais decision, and what is happening to all of those congressional maps. And we'll have a little bit of a discussion about that. Then we're going to do an update from what's happening at the State House. And in fact, both the Senate and the House are currently holding sessions. So not everything is resolved, but we did want to tell you about Senate Joint Resolution 10 and Substitute House Bill 472. And then we'll do a wrap up. I'm going to encourage you to put your name, where you're from, and where you're traveling in the United States this summer. And then also, I'm going to encourage you to put your questions into the Q&A. And so you'll notice that Trevor Martin is here from the League of Women Voters of Ohio. And Colin Marazzi is here, and he is also going to answer questions in the chat, and Elizabeth Warner. And then we're going to also hear from Kelly Dufour from Common Cause. And so with that, Colin, I'm actually going to hand it off to you.
Well, great. And thank you very much, Catherine. And good evening, everybody. Always so great to be with you all. Um, so I'm here today to talk a little bit about our litigation that we filed earlier this year against the state of Ohio for what are some, very troubling provisions in terms of voter access and list maintenance that were included in Senate Bill 293. Now, as Catherine mentioned at the top, the real marquee item of Senate Bill 293 was the elimination of the 4-day grace period for mail-in ballots. And now that's why we now have a election schedule where all mail-in ballots must arrive at their county board of elections by the end of election day. However, what does not get talked about a lot around Senate Bill 293 are some very intricate interagency list maintenance procedures. We at Fair Districts, as well as some of our other, voting rights spaces, have talked a lot about the verification system between boards of elections and Bureau of Motor Vehicle databases and kind of been exposing some of the issues that we've seen there. But there's additional registration verification procedures in that bill using federal systems like the SAVE system, not to be confused with the SAVE Act. I know it's just a very common acronym, unfortunately, and it can be quite confusing. But the SAVE system is the Systemic Alien Verification for Entitlements system. This is a database that is, and actually, database is kind of an inaccurate word for it, and I'll get to that in a moment. But this is a system that is housed within the Department of Homeland Security that federal agencies use to check the citizenship status for individuals applying for social safety net programs like Medicaid, Medicare, other types of entitlement programs. And I say it's not accurate to call it a database because it's really kind of a intra-governmental Google, if you can imagine that. Like you have a search engine where you put an individual's name, and then the SAVE system kind of aggregates all documents and information about anybody who matches that individual name to present to the user, whoever is looking up. Now, the SAVE system is well documented to be a lagging system, meaning it's not routinely updated with new citizenship status, like say after naturalization ceremonies that happen all across the country at all different times. It is very much a lagging system. And so we filed suit saying that you cannot solely rely on save system data to remove people from our voter rolls. There are just too many outliers and too many instances where there are false positives. People are inappropriately flagged. People with common names are often misapplied. So there's a lot of problems that can occur. And this has been well documented across multiple states that have tried to use the SAVE system, most famously Kansas, back a number of years ago. And a federal judge actually had to stop that state from using the SAVE system because it found that 30,000 Kansas residents were inappropriately kept from voting because they were flagged as being a non-citizen. So that's just one example. So we filed suit at the beginning of this year in federal court, and we are very early in the litigation process. We're actually still filing pre-trial motions. However, there are still important developments that are occurring. And I wanted to make sure to flag to this group that we actually have such an extended schedule for this litigation that we have the ability to add plaintiffs to this litigation all the way up until December of this year. So we have 6 more months to potentially find individuals who have been flagged as a non-citizen and had their voter registration status canceled. If we are, we are very interested in finding and speaking to people that are potentially victims of inappropriate removal using the SAVE system. And we have, so we are going to be constantly on the lookout and willing to talk with people that are potentially caught up in this system. We have a trial date set for later in 2027. So, like I said, we still have a pretty decent runway um, before we're actually at trial. But we do have some pretty, some wins to document and mark along the way. And we can go to the next slide uh, to share one of our, a very recent win that we got in this case. So, as part of this litigation and part of the pretrial motions that have been filed by the parties, Secretary LaRose, as the main defendant in his capacity as Secretary of State, has filed several motions to kind of just squash this whole thing. He has filed a motion to uh, um, just a motion to dismiss this lawsuit for lack of subject matter jurisdiction from a federal court, which is not often successful. However, uh, it has been used to end lawsuits previously. But along with that motion to dismiss, he filed a motion to stay discovery, meaning he wants to not even start exchanging documents, going over evidence, really start the litigation process until the federal court rules on his motion to dismiss. And in late May, less than 2 weeks ago, we actually got a win where the magistrate in our case denied the motion to stay discovery. Now, the motion to dismiss is still hanging out there. We do not anticipate a ruling on that, frankly, until the end of discovery, which is going to be April of 2027. So that's a very big win because that allows us to, keep the ball rolling while the judge is considering other motions and while this case moves forward. Had the judge granted this motion to stay discovery, that means that essentially we would have been frozen and locked in place until that motion to dismiss had been, an order had been granted in that decision. So this is a big win, which means potentially we could get relief a lot earlier than if we would have had to have waited until this motion was officially decided. So we are continuing to, engage in discovery, request documents, talk to witnesses, engage in depositions in order to prepare for our trial date, which is again going to be in the middle of 2027. So I know we're about to have some not so good news coming at you, but this is good news. This is a win. And this is something that we should be happy about because, again, This motion for to allow us to engage in discovery allows us to keep the ball rolling and will allow us to potentially win this case sooner than later. So, um, we'll be keeping you updated as this case progresses. Once again, we are very interested in talking to potential new plaintiffs that we can add to this case. So we are going to be very busy come election season and frankly through the rest of the summer. If we hear people that are being contacted by DHS and being removed for the voter register, being having their voter registration canceled, excuse me, we want to talk to you. So please do not hesitate to reach out so we can get some of our legal experts in contact with you to discuss potentially becoming plaintiffs in this litigation. And with that, Catherine, I shall hand it back over to you.
Well, that sounds good. And I was going to say, throw your email into the chat so that people know who to contact. And I know there are folks that want, kind of a deeper dive. You can see I'm tripping over my own tongue. And I highly encourage you to read the materials and, reach out to Colin if you have questions. All right, so this is the section where we talk about Louisiana v. Calais. And I think, one of the things that, many of us have participated in some, educational sessions on what the ruling actually means, but I thought it was worth going through before we started looking at the impact and, how states are reacting to the ruling, just to go through some of the basics. And so, um, we before we even do that, we actually need to take a step back even further to 1965 and the Voting Rights Act. And the Voting Rights Act was established to ensure that everyone had access to the polls. And at this point, we're talking about, 60 years, 60 years of the Voting Rights Act. We do know that in 2013, it was whittled away in the Shelby County v. Holder. And in this particular case, what happened is that there were states, because of their pattern of discriminatory behavior, that actually had to pre-clear. They had to hand in their maps, their plans about voting, all of those things to the Justice Department before they could go forward. And essentially, the U.S. Supreme Court in 2013 was like, well, racism is kind of over. And I've often thought about, that Ruth Bader Ginsburg quote, where she said, this is like, taking away your umbrella, when it's raining because you weren't getting wet. And we're going to see, the real consequences. That was Section 5 that was basically eliminated by the Supreme Court. Now we're talking about Section 2. And in the Calais decision, essentially they forbid any voting practice or procedure that focuses on a history of racism. They essentially say that the map making should be racially blind. And I think this becomes really complicated because many of us will remember in 2019, Common Cause v. Rucho. That was a case where we went to the U.S. Supreme Court with a Republican gerrymander, North Carolina, and Maryland, a Democratic gerrymander, and said, hey, partisan gerrymandering is genuinely problematic. It's certainly something we all know, that the manipulation of our votes mean that we don't participate in meaningful elections. So many different people came forward, friends of the court's briefs, and it was this big moment where we really thought, hey, the U.S. Supreme Court could actually stop partisan gerrymandering. And they didn't. They essentially said, I've always loved this word, it's non-justiciable. Essentially, that the U.S. Supreme Court, federal courts do not have a role in partisan gerrymandering. And what's really sad about this is, first of all, there's no role in partisan gerrymandering. And now they're stepping back from the Voting Rights Act that protected us from racial gerrymandering and racial discrimination. And it is a law that has been used repeatedly to ensure that there's appropriate representation. I think it's important to also know that the Calais decision applies not just to congressional districts, it applies if it's city level districts. It applies if it's the state house districts. It essentially says that in any situation, it's racially blind map making that is the word of the day. Colin, it looked like you might want to jump in.
Well, I just wanted to mention as well as, when we talk about the Supreme Court, we often hear about like activist judges and legislators in robes. It's critically important to the backstory of this case to talk about what actual legislators actually did in 1982
Mhm.
when they reauthorized the Voting Rights Act. And what they did in 1982 was look at previous court cases from the Supreme Court where they had essentially denied relief to African American voters, saying that their rights were being violated because there was not a provable intent that the court could find. And the legislature and Congress went back in 1982 and said, no, 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 intent has nothing to do with it. The effect, the outcome is what we are most concerned about, and that's what we need to stop here. So the legislature actually turned to the court and said, you're misinterpreting our law. Let's
Mhm.
clarify it for you. And that's why in the 1990s, the first decade of redistricting post the 1982 reauthorization, where Congress made clear it's the effect, not the intent, that matters. That's when you see the true proliferation of majority minority districts and actual representative areas all across the American South and elsewhere. Um, it really kind of actualized the full potential of what the Voting Rights Act was meant to be. So this ruling in Calais spits in the face of the legislative process and what legislators actually said, which is that it's not intent, it's effect. And SCOTUS basically said, nope, we're going to take it as intent. And so, you know, I just want to make that point crystal clear because that is another key aspect of the background of why this decision is so painful.
Well, it is. I'm so sorry. I'm experiencing the allergy season a little more heavily than usual. One of the things that is astonishing is that they wouldn't focus on the actual outcome. They would be like, I don't know, the map makers have to be like Bond villains. Mwahaha! It is my intent to racially discriminate. I just think it seems so clear that the what actually is racist is it should be the word of the day. That should be the thing that guides the map making, not whether you can prove that somebody actually intended to do it. So I do think, one of the things that was interesting with the Louisiana maps is they essentially wanted, the folks that live there essentially wanted a second black majority district. So this would be, under the Voting Rights Act, they were calling for this. A court ordered a remedial map to include a second majority district. And the thing that blows my mind is the U.S. Supreme Court heard the Calais, Louisiana v. Calais 2 times. And they ended up saying that the map was an inappropriate racial gerrymander because it prioritized race. In other words, in a place with a history of racism, they created maps that inappropriately focused on creating maps that would allow Black people to elect the representative of their choosing. Now, a lot of people worried that like they would completely eliminate, the Voting Rights Act or any use of race as unconstitutional. And as Colin was saying, the hurdle is significantly different. They didn't eliminate it, but they focused on this question of like, all right, is there an intent? And if the plaintiffs can't prove that there was an intent, then they are able to go ahead with the maps. And I think one of the things that I also think is interesting is they were perfectly fine with partisan gerrymandering. And so one of the things that's really complicated is it's super hard to separate out, like, is it partisan gerrymandering? Did you put a bunch of Democrats together versus did you put a bunch of black people together or Hispanic people? Like when you start to think about like sometimes the overlay of race and partisanship is so close that it's incredibly hard to figure out, from intent. It just makes it incredibly challenging to go to court. And I also think, that whole idea of like acting as if past discrimination and the long-term impact is just not enough to, thinking the courts essentially said that there should be a focus on current data and like what's actually happening now. Now, one might say that what's happening now rises to the level of returning us to Jim Crow. Um, Colin, was there anything you wanted to add?
Sorry about that. I was about to talk off on mute. Um, the only other thing I want to add again, and I have to harp on the Supreme Court because they have unfortunately completely blessed partisan gerrymandering with this
Mhm.
decision. They have gone from Rucho in 2018, where Chief Justice John Roberts says that partisan gerrymandering is a stain on democratic representation. However, we as judges are ill equipped to fix it. To in Calais, less than 10 years later, saying partisan gerrymandering is a legitimate state interest when it comes to redistricting and needs to be treated at the same level as, say, compactness, as equal population, as preserving communities of interest. It's a farce. And it is an absolute dereliction, in my opinion, of the Supreme Court's obligation to secure rights and to protect individual freedoms and our voice in our democracy. So, unfortunately, I think that this, in all intents and purposes, really limits court intervention in nonpartisan gerrymandering cases.
Mhm.
So I think racial discrimination cases in redistricting are going to be very difficult to prove moving forward. And that means it rests with the political branches, with Congress. Um, and so I would highly encourage everybody on this call if you're talking with congressional candidates or talking with neighbors, like a stance on redistricting reform and gerrymandering abolition, it needs to be top of mind because the Supreme Court in this ruling essentially says we are out of the business of protecting against racial discrimination when it comes to gerrymandering. And so it's going to come down to elected leaders and elected representatives. And when you're seeing this redistricting war happen across the country, it's very obvious. No one state is going to be able to solve this. There needs to be a national solution to this. But I think there's opportunity there. And because you have states of, red states and blue states that are both engaging in this, and you have people in those states who are both coming out on the short end of the stick on this.
Mhm.
And so I think there is a possibility for, some strange bedfellows to form a coalition and actually push Congress to do this. Because until then, it's just going to be more of extreme partisan gerrymanders, and it's hard to see a way that shakes out differently.
I think it's incredibly painful after, people in Ohio have worked on addressing gerrymandering for decades. And then there are other states that have worked so hard to do the same. And it really is, at this point, it's arm wrestling over political power and treating voters like we're just pawns. And sometimes when the pain gets great enough, There is a call out and a big campaign and the opportunity for real change. And clearly, it's not the current Congress that we should be focusing on, but we should be thinking long term about getting rules that apply across the country to the map making so that in fact it's fair. And then I know that this isn't the call necessarily to cover this, but I do also think we should also be thinking about what we can do to reform the US Supreme Court, which is not necessarily a fair districts thing, but good heavens, if we're going to have fair districts, we do need a court that is reasonable. So one of the things that I did want to highlight is that, we are talking about, the possibility over the next few years of changes where there could be a loss of as many as 19 majority minority districts in Congress, and then 150 majority minority districts in state legislatures. And so this is very real. This is ongoing. I did think I would start by talking about Florida. And the reason I thought I would start with Florida is Florida, much like Ohio, has really struggled to address gerrymandering. So in 2010, they had a citizen initiative in Florida, and the League of Women Voters of Florida were very active in helping collect all of the different signatures to actually change the Florida Constitution. And so the Florida Constitution actually has a prohibition on partisan gerrymandering in it. Because of their struggles, so they have a prohibition on partisan gerrymandering in their constitution, and they had similar struggles that reflect what we went through. We were horrified at how hard, how they just had to keep redrawing and redrawing and going back to court in Florida, following the 2010 map making and like what that was like. And so we said, okay, if we're going to change the Ohio Constitution, we needed a metric for what gerrymandering actually is, and that's why that proportional representation, that fairness of representation is actually in the Ohio Constitution, because we thought, okay, if they're gonna just basically do whatever because they don't have a strong metric, we will add a metric to the Ohio Constitution that says, okay, let's look at the way Ohioans vote over a decade for statewide office, and that should be the metric. And that's why the Ohio Supreme Court was able to send the map makers back to work repeatedly, was because of that metric. And we learned from Florida, and I feel like, one of the stories about our gerrymandering work has to do with we continue to learn, and they continue to find ways to make things much more complicated and to actually really kind of take advantage of voters. So the Callais decision was announced on April 29th. Now, Florida was all prepared with their remapping. Basically, they just assumed that the Callais decision was going to tell them to do racially blind gerrymandering, and so they essentially went through, and they quickly, right as same day that the decision came down, they passed their map. And it's either a three additional Republican districts or possibly four additional Republican districts. Now we get any questions on Florida before I go any further? All right. So now for Louisiana, the governor actually halted an election, an ongoing election, so that they could redraw the district lines. So essentially, they eliminated one majority minority district. And I think the thing that I have found enraging has to do with an old decision that the Supreme Court made in 2006, where they said it was the Purcell decision. They often call it a Purcell principle, or the Purcell doctrine. Essentially, what happened is, so Arizona, wanted to implement voter ID in 2000 in 2002. And what happened is the U.S. Supreme Court said, no, you can't actually try to do this right before an election. You actually have to stop. And so when we think about that principle, it's the same kind of thing when they say, "Oh, well, we can't actually have a new Supreme Court justice because we're so close to the election." In this particular case, or in this particular case, Governor Landry actually halted the election, created a special election, and and redrew the district lines to meet a decision that had just come down. And then you have Tennessee, where they also really quickly created a map that took the existing majority minority district and broke it up into three districts. And then when you start thinking about Alabama, Alabama has had this. This is another lovely tale of the U.S. Supreme Court. So Alabama's had this kind of history, and so it's long and a little bit complicated. But what happened with them is they wanted to eliminate they had two, keep in mind that 25% black, they had two majority minority districts. And what they wanted to do, those in power wanted to do was to eliminate one of the black majority districts. And what they did is, they created this map, which is the 2023 map. So it went 2021, they redrew 2023. They were told by their federal court, lower federal courts, that they basically had to redraw it. It basically worked its way after Calais, where the U.S. Supreme Court says, okay, because of the Calais decision, you should take that 2023 map that we were like, no, that's not great, and why don't you revisit it? And that three-judge panel, including two Trump appointees, said, yes, this is racially discriminate. This is a racial gerrymander, and that seemed like such a big win, but it went back to the U.S. Supreme Court, and not a signed decision, no explanation. They just ordered that the 2023 map, that racial gerrymander, be used. And so now we're getting to Georgia. Georgia, actually, this is Brian Kemp is the governor there. He decided that they already were in the midst of elections. Remember, he was a Secretary of State. They are redrawing for 2028. And then we have South Carolina, much like our neighbors, Indiana, where what they did is one chamber voted to approve new maps, and the other chamber said no, thank you, and that stopped. Colin, anything you want to add? All right. So I did include this just to kind of give you an overview. A lot of times when we're thinking about this, we're thinking about the impact on Black voters. We're thinking about, well, what does this mean in terms of their representation, and what is it going to be like when you don't have the kind of representation that you deserve to push back on all sorts of, racist and terrible policies? But we should also be thinking a little bit about what this can mean for who's going to be in charge of Congress. And of course, that is part of Trump's major plan. I included Texas here. And the reason I included Texas here is that the U.S. Supreme Court ruled that the Texas maps, with five additional Republican-leaning districts that really divided Hispanic communities and really divided what were traditional majority minority districts, that in fact they could go ahead with their map. And I also want us to think about Virginia, that's not on here. And the reason the Virginia map is not on here is what happened with Virginia is they actually went through this process where, because they have a redistricting commission, they went to the voters in April, and the voters said, hey, you can redraw the maps. The map was immediately taken to the Virginia Supreme Court, and the Virginia Supreme Court said, yeah, no, you can't do this because there wasn't proper public notice before the election. And the Virginia Supreme Court was seeing the election as the early vote period included, not just the election. And so they would say, oh, well, if you take the early vote period, you haven't given proper public notice for this change. And that means that the Virginia Democratic gerrymander, which is also painful, but that one was not approved by the US Supreme Court. And it's very hard to look at that and not think that the US Supreme Court wants to put their hand on the scale. Colin, anything you wanted to add, or maybe Trevor? Well, on that note, I'm going to move along.
Yeah, well, I guess I do want to add some additional fallout we've seen from Calais. And I promise everybody I have 3 more minutes and then will stop torturing you all on with bad news. But we unfortunately have more bad news as it relates to the Calais decision, and it's fresh. It is brand new. On Tuesday of this week, the U.S. Department of Justice issued an opinion. Oh, thank you. Issued an opinion to the Equal Employment Opportunity Commission. This is a commission whose sole responsibility is to make sure that there is, you guessed it, equal opportunity in employment and not discrimination on the basis of any protected class as outlined in the Civil Rights Act. What happened on Tuesday is that the Department of Justice issued a new guideline to the EEOC saying that their disparate impact liability, disparate impact, that's the same term that was used for Section 2 voting rights claims for racial gerrymandering, disparate impact. Their liability under Title VII of the Civil Rights Act, in the Department of Justice's view, is unconstitutional. Now, here linked is the press release that has the full opinion linked in there, should you like to read it. But it's a 25-page opinion, and the Department of Justice cites Calais 14 times in that opinion. And here I have included the literal first paragraph of the syllabus of that opinion, like the truncated, cliff notes of the opinion. This is the very first paragraph. The EEOC, I'm going to just read it for everybody. The EEOC's Title VII guidelines are unconstitutional because they contemplate liability based on disparate effects alone without regard to an employer's likely intent and pressure employers to engage in race-based decision-making. Properly understood, disparate impact liability prescribes only those practices that reflect a significant likelihood of intentional discrimination. Just to be clear, Justice Alito in Calais said Section 2 racial discrimination claims can only succeed if there is, you guessed it, significant likelihood of intentional discrimination. This paragraph that I just read essentially could have just come from Calais. It parrots the exact same line, the exact same talking points, the exact same line of thinking. And so you can see the federal government and the Department of Justice, the Trump administration, whatever you want to call it, trying to extend the Calais decision beyond just voting. I mean, this is the Civil Rights Act we're talking about now. This is employment discrimination. What about housing next? And so these are some of the downstream consequences that a lot of people who follow the Supreme Court closely were saying were likely to happen in the immediate aftermath of Calais. Now, I just want to say, this is incredibly fresh. This only came out Tuesday. I would have to assume that there will be litigation over the implementation of this new policy, but it just goes to show exactly how far-reaching Calais potentially can be in our in the federal government's effort to eradicate real discrimination. So, you know, we at the ACLU of Ohio are following this closely in our national office. I'm sure we will be, following along and providing updates when there is more to update. But, this was an astonishing development that happened this week, and one that, I think there's potential for more, federal action similar to this, using Calais as justification for potentially rolling back other anti-discrimination policies and procedures through federal agencies. So I will officially be done and hand it back to Catherine. Um, so yeah, thank you.
Well, thank you, Colin. So the next batter up is Kelly Dufour from Common Cause. She's going to talk to us about Senate Joint Resolution 10.
Hi, everyone. Thanks, Colin, for that. That's not scary at all. And so as we watch things at a national level, we're also watching things here at the state level play out. And one of those recent, I guess I'll also use the word fresh, things on the docket in the past 3 weeks has been Senate Joint Resolution 10 and House Joint Resolution 9. So these are identical resolutions that proposed a constitutional amendment for the fall ballot and requiring voter photo ID speeding through the State House. We know that on May 18th, Vivek Ramaswamy wrote an op-ed for the Cincinnati Enquirer calling for an action like this the day after state senators and state representatives introduced the identical resolutions, and it has been nonstop from there. So next slide, please. There's important things to point out, but I think one of the things, one of the things is, yeah, oh, that's okay. One
Sorry,
of
I do
the
not have Mia's mad skills when it comes to moving slides forward. I'm so sorry, everybody.
Oh, it's okay. Um, it's important to point out that not only was what the resolutions propose already law, but the sheer speed and confusion during this process for the public to follow, for documents to be available to people in advance, has been really disheartening, to say the least. And so the way Senate Joint Resolution 10 stands today, actually as an hour ago, we know that this is the language. So this is the language that would be proposed to the Constitution, where electors shall provide photo ID in order to vote in person. Like, okay, we know that. And so they did there was a confusing language in the first draft, and they amended that earlier last week and now have said, okay, if there's a different method with which the law passes, the General Assembly allows to vote, there will be a signature and at least one unique identifier. So this unique identifier is going to be a driver's license ID, a state ID number, or a truncated Social Security number, for example. Next slide. So just to give you an idea, I'm not going to run through the dates, but this is just how we have spent our last 3 weeks. It was heard in the House a handful of times. The Senate version was heard in the Senate a couple times. It was passed with the substitute out of the Senate General Government Committee on June 2nd. It was voted, passed out of the Senate, the full Senate on June 3rd. The House started hearings from the Senate's resolution by June 8th. Ironically, the first one that was heard where testimony was allowed was an informal hearing. So that was my first informal hearing experience to watch take place. But we then on June 10th, which is today, which is kind of amazing. Today, they passed it, they heard it, passed it very quickly out of the House General Committee and referred it to Rules and Reference. So seems like a week ago and an hour ago all at the same time, but with that passing out of committee today, that giving 7.5 hearings throughout the last 3 weeks. I'm saying a half because one of them was informal before the House had even uh, officially referred it. But we are watching the House right now, and I don't know, maybe somebody was also dual watching, but I had watched for the first couple hours to wait for this news and have not heard what has happened on the House floor. Next slide. But what we know. So last week and a couple weeks ago, we started getting messaging out. Nothing has changed, right? We know this is unnecessary. We know voter ID laws are already state law. We know this is a waste of power and resources, and there's so much more they could be doing to spend their time on things like impacts of data centers and property taxes and just affordability, right? Of anything to be helping Ohioans. But instead, this is the ballot initiative they're focusing on, ballot measure they're focusing on. Our core message is putting existing state law into Ohio's Constitution is a waste of government resources, waste of time, right? Don't mess with the Constitution. But you have to start thinking a little bit about, okay, what's the motivation? Why is the sense of urgency? We know this ID law has been in effect since 2023 with House Bill 458. Next slide. So this is just some landscape, right, of what we've seen in the past past couple weeks. Started again with a gubernatorial candidate posting an op-ed, where we've seen social posts from the president on this, from Trump on this, and we've also seen a very vocal group of folks who question elections, question machines, question everything under the sun when it comes to elections, come out and say this isn't enough, that this is a fake amendment that's not doing enough. And so when you start putting the pieces together, it's not easy to conclude why this is happening right now, but unfortunately, it looks like we will watch the rest of the House session tonight, but all signs are pointing to this being on the ballot in November. Thank you. And I see other questions.
And to answer your question, that was dropped from the substitute bill that was introduced in the Senate. So that is no longer part of this amendment. So that's actually good news.
Thanks, Elizabeth, for being able to read the chat while appreciate that.
So, continuing in super cheerful news of the State House this week, Substitute House Bill 472 started out as a good bill. It was bipartisan and non-controversial. It was meant to help people without permanent addresses get government ID to participate in civic life. This was a good thing. It passed in the House in February, 91-1, and you all know, you live in Ohio, to have a bill that has that much support, that is actually doing a good thing, is a rare and special thing and to be celebrated. But because we cannot have nice things, on Monday at 5 o'clock, a new sub-bill was dropped and introduced in the Senate General Government Committee. Yesterday morning, like Kelly said, this has been like a crazy week where time has been very elastic. That added 70 something pages and completely perverted the meaning of it and hijacked the bill from a lovely thing to a gross and terrible thing. So this new bill, and it really is a completely new bill, requires photo ID to vote by mail. It introduces an online portal to request ballots, so voters can either submit a hard copy of their voter ID through the mail and requesting their absentee ballot, or they can go through this portal and have a live capture photo of themselves taken to request their absentee ballot. This is a giant bill again, so there's lots of other changes, but those are kind of the takeaways. And so we can go to the next slide. I don't want to keep you in suspense. This passed very quickly. We can go to the next slide. Uh, it was in committee briefly. It had hearings yesterday. There were over 90 witnesses who submitted opposing testimony, including many who had originally supported the legislation, who heartbreakingly had to then say, I can't support this anymore. Also, our leaders, so Catherine, Colin, Jen Miller, the League's director, all testified yesterday eloquently and beautifully as well. Unfortunately, this morning they passed it out of committee. It went to the floor today, and it was passed. So, done deal. Um, I'm sharing some resources here. You'll get the slides later. There has been some media coverage. We sent a press release through Ohio Voter Rights Coalition yesterday. And I'm going to get into the details a little bit more in our last slide, but I wanted to just share some of the top line stuff here. So we can go to the next slide. So why is this bad, you ask? So there are a lot of reasons. Here are the big ones. And again, we're going to be spending a lot of time over the next few days and weeks doing a deeper analysis. We have not had a lot of time with this bill. There are a lot of pages, and frankly, it's also very poorly written. So, on top of there being just a lot of text, it is a sloppy mess, frankly. So, there's more to discover, but these are the kind of biggest things that we've identified. So, first of all, a thing that we talk about all the time, this kind of photo ID requirement just creates barriers for eligible Ohio voters, particularly those who are elderly and disabled. To vote by mail now, we now would have to get our correct ID, get a copy of it, upload it to the portal if we're doing it that way. These are just adding layers of challenge for honestly anybody who's technologically challenged or just easily frustrated by learning new bureaucratic systems, which I may or may not be in that camp. But it also creates particular burdens for seniors, for voters with disabilities, for people who are in nursing homes, for rural voters, for low-income voters, people who are going to have a hard time getting to a board of election, or sorry, a BMV to get a driver's license or a state of Ohio ID who don't currently have one because they haven't needed one. That's going to make participating in elections harder and maybe impossible for some of these voters. So that's really the biggest concern that we have. The next concern is that this is really an unfunded mandate for boards of election. This bill provides no new funding for boards of elections to implement and manage a huge new system. So this is a system that boards would have to invest in new software. So it's facial image recognition technology. They would have to train all new staff, probably hire all new staff. There's cyber security protections. And then election officials would need to have a whole new review process for looking at IDs, reviewing facial images, processing these new requests. And this is just another in a series of unfunded mandates that our legislature has put on these boards of elections. So this is another time that boards are going to have to make some really difficult choices and have to figure out where they're going to have to cut from election administration. And that makes, frankly, elections less secure for all of us. And then this introduces fraud and privacy concerns. So if fraud is truly the concern here, think about everything we've ever been told about sending documents with our personal information through the mail. We're not supposed to do that, right? That's a bad idea. That's what my mama told me. Then think about the thousands and thousands of people putting those documents in the mail in special envelopes that everyone can identify as containing those personal documents during a bookended period of time where any fraudster worth their fraudster stripes is going to know when to look for it. This is not smart or secure, right? So there's that. And then from a privacy point of view, for those requesting their ballots online, so you have to submit a live photo. Um, what happens to that photo? The data retention standards are not clear in this bill. How long are those images stored? Who can access them? Can they be shared with other agencies? Um, there's just a lot of fuzziness here. Um, we know that rushing complicated election law is almost guaranteed to lead to unintended consequences that will, in the short term and maybe long term, hurt voters and election officials. And certainly, if we're being optimistic and we say somebody, smart people, cooler heads will prevail and say, hey, you know what, a mistake was made here. Let's go back and fix this. That's going to take time and money. So, all the way around, this is just a terrible idea. Um, Astonishingly, and because in our line of work, you do have to have some gallows humor or you will um, launch yourself into the sun. The thing that made us all laugh today was there was a quote from Secretary LaRose, sort of up against a quote from the league director, Jen Miller, and the sort of in between was, Secretary LaRose and Jen Miller agree, which I'm pretty sure I've never seen those words next to each other in a sentence before. But the secretary said, I have general concern that when something like this is done quickly, there can be unintended consequences. You don't say, secretary. So, when Frank LaRose and all of us are aligned on election law, that election law is really bad, y'all. So
Mhm.
I want to just leave you with a little bit of hope. So this is passed. The time in the legislature for this bill is done. Um, but because this is such a, I think, overreach on their end, um, we think that there is a path to a veto here. And so that's where we are going. So, like I said, there is so much for us to sort of pour through. And so we're going to be spending some time doing that. But that's where we're going here. So keep your sort of ears pricked for us to be sending action alerts, look to our socials for what's coming next, because I think that us doing really an all-out push for all of these points, that there's fraud concerns, there's security concerns, there's voter disenfranchisement concerns, there's Board of Election concerns. These are all really strong arguments that I think that and again, I don't want to be Charlie Brown with a football saying that the governor could be sympathetic here, but I think that there's a really good opportunity. So I'm going to leave on that positive note. So thanks, everybody.
Well, thank you, Elizabeth. And I just wanted to tell everybody that we'll be sending a follow-up, which will include a way, suggested language for getting in touch with the governor, because it's clearly problematic to do things this quickly and so convoluted and frankly scary, and you could completely turn people off from voting by mail. Um, and so I did want to highlight, speaking of other kind of scary things like surveillance, there is a webinar coming up on Monday, the 29th at 7 p.m. I highly encourage you to check it out. It's about flock cameras and as we think about what else is on the horizon, I did want to highlight that I'm super excited about the next Huddle. So Rory Riley Topping and Josh Raltenberg have joined us previously, so to talk about, what they were working on and what they were seeing with redistricting. They have a new book, Draw the Line in Ohio. And one, it's an infuriating read, but also it's a close examine of our redistricting and the challenges and what was happening. And both Rory and Josh are just really good conversationalists, and I think it'll be a really interesting conversation. So spread the word. We're talking about July 8th at 6 p.m., our regular time. And I think we've exactly hit 7 o'clock. And so I'm going to bid you all adieu. And thank you so much for joining us. Any final words from Elizabeth, Kelly, Trevor?
I just want to say I sometimes feel like I'm spitting into the ocean too, Connie, but I'm happy to be in the ocean with all of you. And the classic, all the little fish in the ocean
Mhm.
going after the big fish, that's us. So we're in it together. And I'm grateful to be in it with you all.
And a big thank you to everybody. We've been at this, these huddles for a long time, and I'm just glad we're all in this together. And with that, I'm going to bid you all adieu.
Good night, everybody. Thank you.